And the question goes that in the act, under the act, that is Succession Act, section 31B, it actually says that a person, it's only movable property that can pass as a mountain causa, Matis donation mountain causa, then again goes ahead to say that thing, that estate could, which let me read as written. A person gives movable property which he could otherwise disposed of by will. I remember in the class earlier you told us that everything can be put under a will, including all movable property. And now we have an instance where actually it is written that that's something that ought to pass through donation Martin Kusa ought.
Wait, why are you calling that thing Martin Kusa?
Oh, mwalimu ni mimi wa mlima.
Umesema Martin Kusa. Okay. Must be nice. Okay.
Yes. Now that thing ought not to have been clearly. It just talks about movable property, and it's not to have passed.
Okay.
I believe you've gotten my question.
So what I would say is this. When it comes to donatio, there's a lot of confusion in terms of donatio and what falls under donatio. But the law is very clear that if you're giving donatio, it must be something that is movable property that would ordinarily be in a will. So that means the meaning of what will be what you're giving being ordinarily in a will is that it should not be something that is exempted from being in a will. For instance, if it is a movable property, it should not be a movable property that is under joint ownership. It should not be a movable property that is under nomination. Okay, that is what it means. So it must be something that you could ordinarily give in a will, but it must be movable property. Are you together?
Yes.
All right, guys, let's start. So we have discussed the question of validity of wills yesterday. Okay, now you can be very sure as death that you get a question on validity of wills, which is a constant question on question one. You always find question one talking about validity of wills. That has been consistent for decades and decades, unless they want to change that tonight or tomorrow morning. So questions on validity of wills, you have no other excuse but to go through validity of wills, understand what validity of wills is, how to prepare a valid will, and so on and so forth. Guys, are we together up to that point? So you will not miss a question on validity of wills. So when we talk about validity of wills, like I've said before, when we talk about validity of wills, just like I've already explained before, what are you looking at? You're looking at majorly three things, or generally, actually three things. Okay. The first one is the question of capacity. Guys, this is very important. When you discuss the question of validity of wills, you must first start from capacity. So what is this thing we're calling capacity, and how important is the question of capacity in this context? Okay. So capacity, you're talking about the mental capacity, that is Bank versus Goodfellow. You are talking about age. You also talk about the question to do with the exceptions of the two. Remember, I said there's the gender rule in terms of age, where we are saying that a child cannot make a will, but they can make a will on the provision that they will re-execute the will upon turning the age of 18. That is number one. Number two, if it is a question of mental status or the mental capacity of the deceased person, we are saying a person that is not mentally stable cannot make a will. However, remember, the exception is they can make a will provided that they are under the lucid moments. Are you guys together? So those are the things you need to look at in as far as capacity is concerned. Okay. The next thing is the formal requirements, which talks about the question of attestation, execution by the testator and the two witnesses. Okay. You need to understand that as much. You also need to understand that as much, because if you don't understand that bit, it is going to be very hard for you to comprehend answering a question on validity of wills. It is going to be hell for you to answer questions on validity of wills if you don't understand the question of attestation and execution. So attestation and execution, we have talked about it, guys. This is a rule under section 11. I do not need to go back and talk about that aspect. More so the question of validity of wills. Right now, your only bet, if you're going to that exam, the only thing you can predict that will come as a matter of right is validity of wills. That is the only thing you know that will come. Okay, the rest of the things you'll gamble here and there, but when it comes to validity of wills, it is a sure bet. You must discuss a question on validity of wills, because that forms the center of the law of succession. So in terms of validity of wills, again, the third issue is the question of vitiating factors. They are normally not there in a question. They don't have to exist, but where they exist, they either affect a specific gift or they affect a specific will, or the will in its entirety. And that is the question to do with mistake, knowledge and approval, suspicious circumstances, fraud, coercion, and undue influence, such things. Those are vitiating factors, uncertainty, and so on. Now, that is the only thing you need to be talking about when you're dealing with the question of validity of wills. Guys, are we together up to that point?
Yes.
All right. So that is very clear. That is what we discussed yesterday. Another thing that we discussed yesterday that I also just want to stress on and just mention is the question of dependence. Guys, this is where it's going to be very, very interesting, because you get questions, around 4 questions. I'm not saying 4 or 5, but generally all the 6 questions are supposed to be around these people. Okay? Dependents and beneficiaries. Who are dependents and who are beneficiaries? Who are dependents and who are beneficiaries? Guys, please let us talk about that. So I've said this before, and this is where you guys will lose the point. The first thing you need to understand who is regarded as a wife within the law of succession. Okay? And specifically, I said yesterday that there are 3 people that must always be regarded as wives at any given point. The first one is the wife under the Marriage Act. That is the spouse that is legally married under the provisions of the Marriage Act 2014. That is the first one, the goat wife. The second person that is of key interest to us is the woman under Section 3.5. The woman under Section 3.5. And we said that for you to be a woman under Section 3.5, you must meet certain requirements. You must be married to the deceased person. You must be married to the deceased person at a time when they were already married, either previously or subsequently, in a system that permits monogamy. And then for you, you must also be married in a system that permits polygamy. So that is the dynamics around the woman under Section 3.5. And then lastly is the woman under Otensaya Wanjiku versus Public Trustee. Now, this has been a very huge debate, a very, very huge debate. Okay, this is where most of you don't agree, and that is where the examiner will be cashing in if you don't agree. Okay, what is the issue here? The issue here is somebody is a girlfriend, somebody is a side, whatever they call themselves. Okay, what is the place of somebody who is a girlfriend or who is just cohabiting with the deceased person during the period of his life? They have children maybe, and all that. What is the position of that? You need to understand that very well and appreciate it. Now, where do you start from? You start from Otensaya Wanjiku versus Public Trustee. That is where you start from. Otensaya Wanjiku versus Public Trustee. That is the first case where the court discussed and dispensed with the question of presumption of marriage. Okay. Now, in that specific case, what did the court say? The court said that so long as you have been having long cohabitation, you have children together, you have investment together, there's a public perception that you are married, then in that respect, we will consider you, we'll presume the existence of that marriage. Okay, that is Otensaya Wanjiku versus Public Trustee. Now, last year, that is the year of 2022, sorry, in the Mary Nyambura case, I think, remember that case? That is a case that you want to read before you get into an exam, because it expounds on the question of cohabitation, and the Supreme Court gives a different analogy or a different approach to the question of cohabitation. Now, in that same case, Mary Nyambura case, of course, the Supreme Court case, the court says, hey, for you to claim for you to claim presumption of marriage, there's few things you need to do. Okay, the first thing you need to do, of course, are the things under Otensaya Wanjiku versus Public Trustee. That is the first thing you need to have, the four that I've already mentioned. Sorry. The next thing that you need to have are the factors that are listed by the Supreme Court, including the capacity to get married, Number two, you need to have the intention to get married. So the Supreme Court explained more and more on what would amount to presumption of marriage. For us to presume marriage, what is it that must be there for presumption of marriage to exist? Okay, so that should you get a question asking you to proceed and advise person XYZ on their interest, on how they can inherit, whether they can inherit from that estate, then you need to ask yourself first whether they're wives. And if they are claiming that they are cohabitees, not really cohabitees, but common law wives, that is as a result of presumption of marriage, then you need to qualify that against that case. I see somebody has already sent it in the chat, so you need to know that case. Now, if there's a school of thought that you guys have, so those of you that go to class B or class C, a very, very wrong school of thought. Okay, that is a very wrong school of thought. If you go with that school of thought in an exam tomorrow, you'll fail. Without any shadow of doubt, you will fail. Okay, you need to read the law as it is and interpret it as it is. Okay, so those of you in class B and C, we know your theory. So please, you want to read that case, because if you are arguing that there's no cohabitation, then the Supreme Court has said clearly that there is, then it beats the analogy, it beats the logic that there exists an instance even within the Evidence Act that somebody can presume existence of marriage. So that is one thing that you also need to understand. Who is a cohabitee and what do they need to qualify to become cohabitees? Still not to become cohabitees, but to have the presumption of marriage. What do you need to have? Long cohabitation, public perception, and all that. Are we together? And after you qualify that, then you can now advise that person that they are wives as a result of that specific presumption of marriage, and then they can now petition for grants of administration, whichever the type of grant that you are dealing with. Guys, are we together?
Yes, we are.
All right. So that is clear. So read that case. I'm not going to read that case for you. I will not take any question on that case. None at all. None at all. So please, let's go to the next thing that I want us to discuss, which is a question to do with intestacy. But before we get to intestacy, I also need you to understand, even before, once you understand that, guys, there's usually two things you need to understand when it comes to probate. There are two things you need to understand. The first one, generally, the question of wills, validity of wills, that is basic. Number two is the procedure of getting a grant. The procedure of getting a grant. You need to understand that process, guys. I'm going to talk about it later, but for now, let us run through the question of intestacy. Let us go through intestacy very quickly because there are a few things I want us to understand about intestacy. And of course, guys, sorry, I'm forgetting something. In terms of the rights of in terms of the rights, all the factors must be there, or at least actually all of them must be there. Okay, so please make sure that you have all of them in that case. So read that case to understand. Read that case to understand. All right, so let us move forward and talk about something else, which is the question of, oh, I was forgetting something. When it comes to dependence, I've mentioned the wife. Now we have children. Who is a child? That is also very, very clear. There's nothing to talk about when it comes to children. But also a dynamic that you need to understand is the category of children. Not really category, but sometimes if you read the case of Rono versus Rono, I think that should be the case, Rono versus Rono, the rights of the female children have been expounded in that case. Okay? The the privileges and the rights, not really a privilege, but the rights of female children. Okay. Now, this stems from an instance where previously, even in some societies, female children are not supposed to inherit to certain degrees. Okay. What does the law of succession say about the right of a female child? Okay. Are female children treated the same way as male children? Okay. If your answer is yes, then what is the provision about that? Okay, what is the provision? Of course, starting from Article 27, the freedom or the right to non-discrimination. You go to Section 38, 38 of the Law of Succession Act in the instance where the deceased person has left behind children and no spouse, and the act provides that everything shall be devolving to that child or children equally, regardless of their gender, as well as you look at the definition of the term child within the act and whether it gives any emphasis to gender. So you have to have that perspective when you're going to address questions to do with children, because you might get a question telling you that this person died, is having female beneficiaries, or left behind daughters. Maybe the society is now saying the daughters are not supposed, whatever that is. Okay, you might need to also understand that. And then, of course, children that were taken in by the deceased person, also you have to understand that. So let's go through the law of intestacy and make it very quick. So in terms of intestacy, you just need to understand first what intestacy is.
Excuse
Sorry.
me.
You're not excused. Mute your microphone, please. Questions are
My
not
answer,
taken now. Okay. Questions are not taken right now.
let me just a
So
clarification, kindly.
what is it something that requires my answer? If it requires my answer, that is a question I don't want to take now.
Okay.
Yes, what this is what, because I know you guys, if I open the floor right now, you guys will say everything, and then we will not be able to get done with what I want us to talk about. So in the alternative, this is what I would suggest. If all of you agree, again, subject to your agreement, okay, we can go through what we're discussing. In the meanwhile, take note of, I usually say this in class, but you guys don't take it seriously. Take note of your questions, maybe in a piece of paper or whatever, note them down. Once I get to a certain point and you have a question, we can answer all those questions or at the very end of it, so that we move with speed so that we don't overstay here. Is that workable with everyone?
Yes, let's take the question after the class.
Thank you very much, Kamiri John. Sawa. So let's talk about intestacy. So guys, probate is just a storybook. That's what you need to understand. Probate is just a process captured in a story. Okay. So when it comes to the rules of intestacy, the first thing you need to understand is what is intestacy? What are the instances of intestacy? Okay. What are the instances that would give rise to intestacy? So the first one, of course, is that the deceased person has died wholly intestate. There's no will at all. The second one is that there's partial intestacy and partial testacy. This is where the will has been made and the will covers a part of the estate, and the will doesn't cover part of the estate. Okay, that is also a question to do with intestacy. And also an intestacy will arise in an instance where the deceased person left behind a will, that has since been declared invalid. When the will is declared invalid, then the deceased person is treated as if there was no will. Okay, that is the question to do with the instances of intestacy. So again, quickly, the rules of intestacy from section 35 to all the way to section 40. 35 to section 40. So in terms of the rules of intestacy, you just need to understand what happened in that instance. So the first instance is where the deceased person has left behind a spouse and a child. If the deceased person dies today and leaves behind a child and a spouse, okay, this is a question that you ordinarily even find in question 1. Okay, because question 1 normally tends to ask a lot of everything, a little bit of everything in everything. Okay, everything in everything. What is the meaning of everything in everything? So question 1 is very wide, and that is where most of you will be losing marks. Losing marks not in terms of writing the wrong things, but spending a lot of time in question 1. 1 hour in question 1, you move. If you spend more than 1 hour in question 1, you shall receive this paper without a doubt. Okay, don't spend more than 1 hour in question 1 because there's no time. Those questions are too long. Okay, you can't spend more than 1 hour in one question. So please manage the time very well. So in terms of this question, you'll be given an instance. The good thing is that these questions are not direct. You'll just be told that this person died and he was succeeded by the wife or the spouse and 2 children or 3 children or whichever. Now, from that instance, you're supposed to advise them on how the estate will devolve. Now, the rules of intestacy are very clear that where the deceased person has left behind a spouse and a child or children, then, number 1, the personal and household effects will go to the spouse. Absolutely. The personal and household effects will go to the spouse. Absolutely. That is very, very important. Now, sometimes you need to understand what is the personal and household effects. Okay? Remember, guys, what you're getting as the spouse of the deceased person, okay, is the personal and household effects. Absolutely. That is the only thing you're going to get. Absolutely. Absolutely means these are yours. Now, within the Act, personal and household effects are defined under section 3. You know, it includes everything within the house and the personal effects, excluding the car. Okay, so everything within the house will form part of the personal and household effects, excluding the car. Okay, so if your husband dies, then you will inherit every personal effect that they had, including everything that is in that house. Are you together? That is a personal and household effects. Okay, and of course that is where you get the things like the shirts, the clothes, you know. Yeah, there's a saying normally that malipo ni hapa hapa duniani. You've heard that word? Yeah, some of you, I'm not saying all of you, some of you are fond of buying their partners very, very unreasonable things on their birthdays. Socks, boxers. Those things are personal and household effects. Akikufa, wewe ndio utabaki nazo, utazivaa mpaka uchoke. Unasikia? Those socks you keep buying every birthday, socks bale moja, utazivaa mpaka uchoke. That is how the world works. So buy your partner something that you can have, you can be proud of, to inherit when they go. Please learn from that. So the personal household effects are absolutely transferred to the spouse. And then secondly is the life interest in the whole of the remainder of the estate. And then after or during the pendency of that life interest, they can apportion part of that estate to the surviving children through the power of appointment. Okay, and of course, that comes from the traditional setting of the Kenyan societies. So the children will only get what they're given by their mom or their father through the power of appointment. Are we together? And in that instance, if there's any child that is not happy with the power of appointment, then they need to go to court under Section 35 and tell the court that they're not happy, and the court will give them reasonable provisions. Are we together? Reasonable provision. And now that I'm mentioning reasonable provisions, guys, you need to understand reasonable provisions. Again, this is also where there's a problem, and this problem is coming from class B and class C. You know, how do I know that? I attended those classes myself, so I know class B and class C, you have a problem. Reasonable provisions is under Section 26. Okay, it is one question that never misses. So you need to be very keen in terms of reasonable provisions, because you'll be told James is left out of the will. Okay, James is left out of the will, or Kamiri John has been left out of his father's will. Maybe Kamiri John is a bad person. Okay, so his father doesn't like him. He's been left out of the will. They've come to your office. Kamiri John is claiming and complaining that he wants to be given something in their father's estate. Now, what is supposed to happen to them? What do you advise them? And we talked about this in the last class, and I said, in terms of reasonable provisions, there are things that must be done. Okay. Number one, you need to ask them whether they're dependents. Yes. If they are children of the deceased person or spouses of the deceased person, then they are dependents. Okay. Number one. Number two, you ask them whether the grant has been confirmed. Because if the grant has been confirmed, there is no reasonable provision. But if the grant has not been confirmed, then you go to the question of how, which is under Section 26. What is 26 saying? That any person that feels that whatever they've been given is not adequate, okay, they should make an application. They should make an application. So most of you normally know that you make an application under Section 26. But the big question in the room is, do you know how to draft that application? Okay? Because for a long time, if you look at even the previous settings, you'll be told, advise person XYZ on the procedure of getting the grant. And then what is the advice? Proceed and prepare the petition for grant, and then lodge the petition for grant and attach these documents. And then from 2021, the dynamics change. Okay? In 2021 now, the examiner is now asking, draft that petition. Okay? Draft the petition. Are we together? Now, the same thing. In most of the times these questions have been set in terms of reasonable provisions, the examiner will be telling you, advise person XYZ on what to do. Okay? And most of the times you've been answering by saying, file an application under Section 26 and you ask for reasonable provisions. The question is, what if the examiner was to tell you to draft that application yourself? Would you be able to draft that application? Very, very important. Okay. Now let's go back to the second one. So the second one is where the deceased person has left behind just a spouse. There is no child. So in that instance, the spouse will be entitled again to their personal and household effects, the personal and household effects of the deceased person, absolutely. Number two, the spouse will be entitled to 20% of the estate, absolutely as well. And then number three, the spouse will be entitled to a life interest in the whole of the remainder, a life interest in the whole of the remainder. Now, it is important for you to understand that that life interest doesn't terminate upon remarriage. Okay, upon remarriage. Why is that the case? Oh, sorry. I don't know why you guys lost me, but what is the last thing you heard me saying? Have you heard everything I've said? I'm assuming you have.
Interest does not terminate upon remarriage.
Okay, yeah. So that interest does not terminate upon remarriage, and the reason why it doesn't terminate is because the High Court declared it unconstitutional for the reasons that I've already explained. Okay. Now the next one is where the deceased person leaves behind just a child. and no spouse. In that instance, you proceed and divide everything to the child or the children absolutely. The child or the children absolutely. So sorry, I mean equally. Sorry. So if there are two children, of course, each of them will get equal share of that estate, and that includes, okay, that includes, I mean, the provision on non-discrimination. So we make sure that you don't discriminate on the female children. You don't discriminate on the female children. So all of them will inherit from their father's estate or their mother's estate without any discrimination. That is the question of where the deceased person has left behind children only. The next one is where the deceased person has left behind no spouse and no child. Again, this specific provision, we are talking about section 39, where everything shall go to the deceased person's father and mother, and where they're not there, the sisters and brothers. Where they're not there, half sisters and half brothers. Okay, so that is the rule. That is the rule when it comes to instances where the deceased person left behind no spouse and no child. Okay, now of interest again is the question of polygamy. The question of polygamy. So when it comes to polygamy, guys, when it comes to polygamy, what are we saying? When it comes to polygamy, what are we saying? Very simple things. Now, first, you need to understand the beneficiaries in polygamy. Okay, when somebody is polygamous, potentially polygamous, okay, then what is the rule when it comes to the distribution of the estate? You need to, this is like the exception to the rules that we've talked about. So it is a special case. So you need to understand it because it is strange in its own nature. So when it is polygamy, then what are you supposed to? What are you supposed to do? What are you supposed to do? All right, so number one is that the beneficiaries are the surviving spouses and the children only. Okay, surviving spouses and the children. And the children here includes those that were taken in by the deceased person as his own. So those are the spouses when it comes to, sorry, those are the beneficiaries when it comes to the question of polygamy. So what are we saying? That each spouse, I mean, all the children will be regarded as individual units, with the spouses being additional units. That is number one. Number two, the personal and household effects shall remain in each house. Every house or every spouse shall be entitled to the personal and household effects that are in their houses. Are you together? So that is the rule when it comes to polygamy. So the children are units, and then of course the surviving spouses are additional units, and everything shall be divided equally among all the units. Are you together? And the personal and household effects of the deceased person shall stay within their houses, and they shall be entitled to that absolutely, depending on what is in their house. Guys, are we together? Are we?
Yes, we are.
Yeah. Please repeat that point.
Which point?
Repeat the polygamy aspect.
Explain it for me, what you've understood. Let's start with you, and then we can see where you're losing us. What is the rule on polygamy? Please speak up.
For polygamy, my understanding is that all children of the deceased person will be regarded as dependents, and the personal and household effects, if now in this case, usually the women are living in different places, they shall remain in those specific homes. Yeah, that's what I've understood.
So are you answered, or what is your question? What is your specific question so that we can address it?
I thought there's more to it, but if that's all, then we're on the same page.
Oh, sorry. No. Polygamy is very simple. Just keep it simple as that. It's very simple. Each child is a unit. The spouses are additional units. Everything is divided equally among all the units, and every spouse shall be entitled to absolute ownership of everything that is the personal and household effects that are in their respective houses. I hope that is clear now. So let us go to something else that I want us to talk about again. So that is that is the question of polygamy. So apart from polygamy, again, you might also want to understand how to construct a schedule of distribution, and in this essence, a schedule of distribution will only come from the instances we've said, so that if this person is a polygamous person, then you know how the schedule of distribution will be looking like. If this person is or left behind a spouse and a child, you know how it will be looking like. If this person left behind just children, you know how that will be looking like as well. Are you together? So that is as simple as that. So that is the question of intestacy. Any question up there? I can take one or two questions, just two questions only. Two questions only, and then we can go to something else. Apollo?
Thank you for the chance. My question is on other people in the family. So, say they are adopted children. How are they getting? What are they receiving from the state, or is it just excludes? Is it just for the spouse and the children?
But you say it, adopted children are children. Are they not? You just call them children.
Okay, how about grandparents?
Grandparents can go be with Christ. They're not entitled to that estate. Are you together? Your grandparents are not entitled to your estate. They can go be with the Lord. Okay? They are only regarded as beneficiaries under Section 39 when, remember, when the children are there. Remember, Apollo, we are starting from Section 35. What are we saying? 35, what is it saying? Number one, okay? Number one, you leave behind a spouse and a child. Everything goes to your spouse and your child. Number two, you leave behind just a spouse. Everything goes to your spouse. Okay? And then you leave behind children. Everything goes to your children. Okay? You leave behind no child, no spouse. Everything will go to your mom and your dad. If your mom and your dad are not there, everything will go to your sisters and brothers. If your sisters and brothers are not there, will go to your stepsisters and half brothers and half sisters. If they are not there, that is when we'll be moving closer to your grandparents. So they are not in priority. They will only inherit if the people that are listed in priority are not there. Tunaelewana?
Okay, how about those who are being maintained? They're not part of the family, but they can show that they were being maintained. So are
Like
they
who?
provided for?
Give me an
Those like
example.
Section 29B.
Who?
Okay, let me read it.
Don't read
So for
anything. Just
instance,
answer the question. Give me an
we have
example of who.
children that were taken in,
But that is
and then
exactly
we
what I've
have
explained, my friend. I've just said children. I've just mentioned children. I've mentioned half brothers. I've mentioned half sisters. I've mentioned parents. I've mentioned grandparents. So who again are you asking about? Mm-hmm.
my question is,
Mm-hmm.
will they be included in the units when you're dividing the estates under
And like
Section 4?
and like I've said, there's a list of priority of people who can benefit from the estate of the deceased person. And those people can only inherit if they fall within the categories listed under 29, which I've already explained. Are they a child? Are they wives? Tick. Okay. Now, if they're not children and they're not wives, then we go to B. What is B saying? B talks about the people that must show maintenance. And who are these people? These are people that okay. Keep whispering. Okay. Whoever is whispering there, just whisper. So I'm talking about the people that are listed under 29, and these people specifically must show maintenance. For them to be given anything, they must show maintenance. They are not entitled. Remember, guys, the list under 35 to 39, they don't. These are people that have automatic right of inheritance. Okay, everybody that is supposed to show maintenance is not provided for within 35 to 40. So we are simply giving instances. Okay, so if you get in a scenario where the deceased person left behind no child, no spouse, no grandchild, no grandparent, or the deceased person died and left grandparents alone, then that is under section 39. The entire thing will go to the grandparents because that is the person in priority. So we ask ourselves, who is in priority? Is it the spouse or the child? Is it the parents, sisters, brothers? When it comes to polygamy, then these people must be existing. So the additional units must only be the children of the deceased persons. Okay? Children of the deceased person. Number one, the spouse first, and then the children of the deceased person. These are children that were given birth to by the deceased person. That is number one. Number two, they must be children that were legally adopted. And then lastly, if they're children that were taken in and being maintained, they are not children of the deceased person, and therefore for them to get anything from that estate, it will not be as a matter of right. It will be a matter of maintenance. So for them, they'll have to show maintenance. In most instances, they'll have to go to court and then get an order of reasonable provision after petitioning the court or making an application to court. Are you together? So they are not entitled as of right. They will have to show maintenance later. The same way, if the deceased person left behind the spouse and the wife and the mother is not entitled to inherit from that estate unless she has shown maintenance. Okay? Tunaelewana?
Yes, thank you.
All right. Thank you very much. So that is the schedule of distribution. In terms of intermeddling, very, very important, guys. Intermeddling is very, very important. Now, intermeddling is important because you will be told, or you might be told, to discuss the questions to do with the grant article, legenda bona. Okay. Now, when it comes to intermeddling, this is an instance where the deceased person's estate is being squandered by somebody or is being managed by somebody that doesn't have the authority to do so within the law. Okay. Where is this authority coming from? Where is this authority coming from? Number one, the will, the grant, or any order of the court. The will, the grant, or any order of the court. Are you together? That is an instance that will give authority to a person to deal with the estate of the deceased person. So if you are dealing with the estate of the deceased person without a grant, then, or without a will, then you become an intermeddler. How do you deal with intermeddling? First one, you report the matter to the local administration, that is the area chief. It is old school, but that is what the law provides even now. So there's nothing you can do about that. It is still what the law provides. Number two, you can always go to court and seek an injunction under Rule 63 of the Probate and Administration Rules. You can make an application for injunction, asking the court to issue an order restraining the intermeddler from intermeddling with the estate of the deceased person. And then thirdly is questions to do with ad colligenda bona. Now let's talk about the limited grant ad colligenda in this context, of course. Okay, in this context, of course, we are talking about the question to do with intermeddling, and we are saying that if there's a chance that the estate is going to waste away or be squandered in whatever way, you can go to court and get an order of a grant ad colligenda bona, and the court will proceed and grant you the privilege or the opportunity to gather, okay, to gather the estate of the deceased person and safeguard it. I don't know whether you understand exactly what I am saying. So, ad colligenda bona, you need to understand that aspect of ad colligenda, more so in the context of you're being told that the deceased person's estate is wasting away, for instance, or perishable for whatever manner. Okay? And most of in this context is the question of farm produce or anything else that is perishable. Okay? So how do they rescue the estate? How do you stop the estate from wasting away? And that is through the process of applying for the grant ad colligenda bona. So you have to tell them how to apply for that grant. How do you apply for grant ad colligenda bona? You go to court through the prescribed form. You don't know the form. You don't need to mention the form if you don't know the exact form. Okay, you can always use the word prescribed form. Are we together? So that is ad colligenda. So in terms of intermeddling, it comes there, but we'll talk about ad colligenda at length when you get to the question of grants. The question of grants. All right, I think that is the end of intestacy. Any question on intestacy, and then we can go to grants. We can go to grants and we can go to grants. Somebody? Any question? Please, Chepkemoi.
Hi, thank you. So I have a question regarding, well, what we've just been able to discuss from section 35 all the way to 40. And I just wanted to find out this net intestate. We are saying that depending on the various sections, we're saying that, okay, for instance, let's talk about section 35. So you're saying the spouse has a life interest in the net estate. So the assumption here is that these are the only people who are trying to get this property. We're not talking about any other person who's perhaps going to court, or we're not talking about a grant at this point.
I'm not getting your question.
So I'm just wondering, like so when do these other people come into question? Supposing there is a brother who wants to prove maintenance, yeah? So then they will get which property? They will get property from the life interest.
Yeah, if you go to court and get another reasonable provision, you'll get that from the life. The net estate that is under life interest. So
Okay.
the the wife or the spouse will have a life interest in all of the remainder. But at any time, the court can give an order. Somebody's having the video on, please mute. The court can give an order that a person be given access to the to the net estate. So if you are having less than net estate of 10 million shillings, then part of this 10 million can be given to someone if they apply for reasonable provisions.
Okay.
All right. Eve?
Divorced wife, can a divorced wife petition for?
No, just stop there. Divorcees are not, there's not, once you're divorced, you're divorced. You're not a relative of that person. A divorced person is not even a relative of that estate. So, for the divorce, apana. Somebody mute your video. Wanjiru Gikonyo, please zima video. So a divorcee is a divorcee. They're gone, never to come back. Okay. Ashley, Mbula.
Just a clarification on what you said about children who have been taken in by the deceased but are not really their children. In section, I think this is section 3.2. Yeah, 3.2. It states that children should, for the purposes of this act, children shall include a child, all of that, and in relation to a male person, any child whom he has expressly recognized or for whom he has voluntarily assumed permanent responsibility. So does this mean that children for whom he has assumed permanent responsibility are dependents under just as children? Because I think what you said was the contrary, that they have to apply to court as beneficiaries. So I'd like clarification.
Where did you hear that? Where did you hear me say that they have to apply to court? Where did you hear that?
I think what I heard you say was that a child that the deceased has taken in, but is not their own child, they have to apply to become they're not independent dependents, is what I mean. Like they're
No,
not
they
like
have to show maintenance. For them to get
Yes,
something
show
from this, they have to show maintenance. So most of the instances, they'll be applying for reasonable provision, and of course, they have to show when they're applying for that reasonable provision, they have to show maintenance, that I was being maintained. Okay.
Now that's where I need clarification. Because the act states that a child, for the purposes of the act, includes those who the deceased person has been maintaining or taken up responsibility for. And then in section 29, a child is stated as not needing to show maintenance. So which is which? Is it that
Those things are not contradicting each other. There are still, I've said, guys, there are three people that will form part of the category of a child. The first child is a child given birth to by the deceased person, an adopted child, and a child that is taken in by the deceased person. All those are three children. They are children, but one of them must show maintenance. The first and the second, they automatically inherit. The act in defining a child does not say that this child will automatically inherit. No. If you go to section 22, not 22, sorry, 29, who's that who is speaking? Mbula. If you go to 29, 29 gives two categories. The first one, 29A, talks about the children of the deceased person. They don't have to show maintenance. And then 29B talks about the children that were taken in. They are still children, yes, taken in by the deceased person, but they have to show maintenance. Tunaelewana?
Yes, thank you.
All right. Lastly, Omwenga. Not Omwenga. Let's have Apollo, Omwenga, and then Apollo. Those are the two questions I'm taking, and then we go and talk about the grants now.
Thank you, Mwalimu. I wanted to know whether there is a difference between grant decolligenda and grant bona defact.
Bona what?
Defact.
Bona defact. No, there's no grant like that. Bona defuncti. So it's the same grants. Grant adcolligenda bona. Adcolligenda bona. Defuncti. It's not. They're not two grants. Just one same grant. Are we together?
Thank you.
Yes. You're welcome. Apollo, lastly.
So I'm seeking clarity on section 36. You've said that the life interest that the spouse will gain will not determine upon her remarriage. So that also, I would presume that it applies to section 35 that has the same provision. So can we say that the Law of Succession Act needs to be amended, and which provision of, rather, which case law can we rely on if we have to say that because the LSA is still saying that that if she remarries, she will lose that life interest.
You know very well that was amended by the High Court. So the fact that it is still there doesn't mean that it is legal. It was declared unconstitutional by the court, as well as various sections were declared unconstitutional. So find that case law and read it. So that provision of life interest was declared unconstitutional. So it will be amended finally, or it should be amended. Yes, it will be amended finally, but the age is taking time. So until then, just know what the law says, which is that the life interest will not terminate upon the death of the deceased person. I mean, upon the remarriage of the deceased person's spouse. Are we together?
Yes. Is that the case of Ripples International?
Ripples International is the one that amended Section 2, Section 3. Actually, should be the same case. But check it out. You know, you're asking me and you should have read it. Have you read that case? Umeisoma
Yes,
kweli?
I think that's the one. Yes. It
Good.
amended Section 39 and also 35 and 36.
Good. Mutinda. I think I don't want to take any question now because you guys are late. Mutinda, put your hand down. Let's go to grants. And we take questions once we're done with grants. So in terms of grants, you need to understand grants. But first, the process of getting a grant. Guys, let me make it clear. You must understand the process of getting a grant. The process of succession is very important. So all the time, please make sure you understand that. So let's start from the very basic, the types of grants that we have. We have 3 types of grants. Okay, we have 3 types of grants. Okay, what is the first type of grant that we have? What is the first type of grant that we have? We have the grant of probate. Grant of probate. We have grant of letters of administration with written will annexed, and we have grants of letters of administration intestate. Are we together? Grants of letters of administration intestate. Now, these grants are the main grants you'll be applying for in any context. Are we together? So the next thing you need to understand is the process of getting this grant. What is the procedure? Number 1, if you are given a question and you are told to discuss the procedure of administering the estate, then you first need to know which type of grant are you going to be applying for. Okay, which type of grant are you applying for? Because if you know it is a grant of probate, then you know you're going to talk about filing your petition for letters of grant of probate. If you know it is a grant of letters of administration with written will annexed, you know you're supposed to talk about filing the application, petition for letters of administration with written will annexed. So the type of grant is very important. So you first have to establish what type of grant are you talking about. That is the first one. The second one that you must also understand is the question of limited grants. But before we get to limited grants, please let us go through the process of succession. So that is very important because you most definitely should be able to get a question like that. If you don't get a question like that in an exam, it means you sat a different paper. You know, you could be sitting a different paper from the rest of everybody. You know, you'll go to the wrong exam center and you do a wrong exam. If you go to that exam and you don't see any question on grants, you need to ask yourself, where am I? And then you can ask them to take you to the right exam center. But essentially what I'm saying is that the process of administration is a common question all the time. So the first one is you file an application for grant. Once you file that application, there's verification by the registrar. There is the propoundment of a will if the will is there. If the will is attached, there's a propoundment of a will. Propoundment of a will. Should there be no will, then of course the judge or the magistrate in that case will proceed and verify or approve the application. Let's say approve the application for gazettement. And then we have gazettement. If there's no objection, we have the issuance of the temporary grant. Okay, and then after that, application for confirmation, and then confirmation, and then distribution, and then reports, the reporting stage. Are we together? That is the procedure. So at any time, you start from filing an application or filing the relevant documents. So that is grant of letters of administration intestate, or letters of administration with written will annexed, or grants of letters of probate. Okay, that is the first one. And then the second one is this specific application is verified by the registrar just to confirm that you filed the relevant documents. Okay, that is that. After that, we shall go straight into the question to do with propoundment of a will. The will is propounded by the judge or the magistrate, and then we go straight to gazettement. The application is gazetted in the Kenya Gazette or published in the Kenya Gazette for 30 days. And then after that, we have the issuance of the temporary grant. Okay, once the temporary grant has been issued, then if there's no objection, of course, that is when you issue the temporary grant. Once the temporary grant has been issued, 6 months within that, after that, you're supposed to apply for confirmation of the grant. And then the grant is confirmed. Once the grant is confirmed, then of course you get a certificate of confirmation of grant, which you proceed and distribute the estate. And then you report back to court in terms of how the administration or how the distribution was undertaken. That is the process. So have that process at the back of your mind should you be told to discuss or advise somebody on the process of administration of that specific estate. All right, so that is the question of grants. In as far as the types of grants that we have, in as far as the procedure is concerned. You need to understand that. Okay, you need to understand the process, the procedure, guys, all the time. You need to understand that process. If you forget about that, then it will not be good. The next one is limited grants. And limited grants, I want us to talk about the grant adequately gender bona on all types of the limited grants that we have. So let's start with grant adequately gender. Somebody unmute, tell us what grant adequately gender bona is, and then give us the process of getting the grant adequately gender bona, and the grounds that you need to demonstrate. Somebody unmute or put up your hand and tell us what is the grant adequately gender bona, when does it come up, and what do you need to do to get it, and what are the grounds you need to show. Number one, somebody put up your hand. Grant adequately gender bona. Guys, limited grants. So once you know the main grants, I've said that 3 main grants. The first one is grant of probate. This is where there's a will, and the will has appointed a testator. Sorry, an executor. That is the first one. The second one is grants of letters of administration with written will annexed. The third one is grant of letters of administration intestate. So all that you understand at what instance they are going to come up. Once you understand that, then we have limited grants now. Certain instances within the probate law where we will need to take out a limited grant. What are these instances? That is what I want us to discuss right this minute. So somebody put up your hand and tell me, when do you take out a limited grant adequately gender, and all other types of limited grants that we have. So just mention them in passing, but for you to master that, you need to understand a few things: what it is, what circumstance will give rise to it, and the process of getting it, and also the ground that you need to demonstrate. Now, the examiner will not call you sweet names when it comes to this one. The examiner will never put a billboard for you to tell you that, oh, my dear, now this question we're talking about grants and limited grants, that will never happen. Okay, you will be told that James is the deceased person. James has died. James has left behind his farm in Kitale with maize or crops on it. These crops may be let's say subject to they are perishable, they're going to waste away, or maybe stolen, whatever. Proceed and advise the spouse of James on what they need to do or what she needs to do in that circumstance. You get the point? So in that question, what is the answer? Yes, a word.
Okay. Can you hear me?
I can hear you.
Okay. Grant ad colligenda bona is a grant for collecting the goods of the deceased. It is provided for under Section 67 of the Law of Succession Act. It applies where it is necessary to secure the estate assets that may be at risk pending the administration.
She has disappeared. Somebody. She has disappeared. Let's see if she will come back. Meanwhile, somebody put up your hand and give us, she's there. I will proceed.
Can you hear me?
Mm-hmm.
I was at the point where I was saying it's provided where it is necessary to secure the assets of the deceased. And then the administrator is given powers only to collect and preserve the grant pending making of a full grant.
You've not explained. You've not explained a few concepts that are very important. But anyway, somebody tell me. Kamiri John, what do you need to add then? Mm-hmm.
As he has said, at Collegiate Bona, two factors are very important. That is, of course, it is for collection and preservation. In which scenario would you need? Number one, if the estate of the deceased has some properties that are perishable in nature, that they are likely to be destroyed. Or secondly, in a situation where there may be part of, say, the administrator or other people who are likely to intermeddle and interfere with the estate. At those two scenarios, you need to ask for a collegiate bona so that you can be able to collect and preserve.
All right. What is the procedure? You guys are not giving me the procedure.
The procedure is you will apply, you will petition the court to grant the.
Is it a petition? Mm-hmm. And of course, you don't need to mention the form. Don't mention petition number this. Proceed. Petition to the court.
You just ask the court to grant a temporary grant ad collegiate bona. In the meantime, as you wait for the confirmation of the grant, and yeah.
Okay. All right. So you guys are not okay. Fine. So let's build on that. So guys, that is grant ad collegiate bona. This grant comes in an instance where the deceased person's estate is perishable or is composed of perishable goods or perishable property or plants or crops, whatever that is part of that estate, or the estate is at the risk of being wasted away, okay, being squandered away, or if they're not collected, they will waste away. If they're not collected, they will waste away. Are we together? So that is exactly what I'm talking about. That is exactly what I'm talking about. So that is the grant ad collegiate. So how do you approach the court? Of course, you approach the court through the prescribed form. The prescribed form in this case is should be form 85, but you don't need to mention the exact form. Just indicate you go to court with the petition the court in the prescribed form together with the affidavit. So don't have to mention affidavit number 19 and form 85. You don't have to do that. Okay, that is not important. What is important is you understanding the scenario and you explaining clearly to your client in the question. So that is grant ad colligenda bona. Okay. What other types of limited grants do we have? We have grant ad litem. Of course, you know what ad litem is. Ad litem is an instance where there's pending litigation. Ad litem is where there's pending litigation. Not really pending litigation. That is pendent lite, but ad litem is whereby you want to sue on behalf of the estate of the deceased person, or you want to defend a suit on behalf of the estate of the deceased person. Okay, and that instance you go for the grant ad lite. Okay, and then you have an instance of pending litigation, that is the grant pendente lite. And then of course we have the boni non-administratis. You know those grants, guys. I don't want to spend more time there, but make sure you understand the specifics of each and every limited grant and the circumstances giving rise to those grants. Are we together? So that is important. That is important for you to understand. So please make sure you live up to that requirement. Now, after that, let's go to the question to do with who can be given a grant. Of course, this is something we discussed before. I don't want us to get so much into it. Who can be given the grant? Of course, a person that is above the age of 18, a person that is above the age of 18 must be given a grant, or can be given a grant. Any person that is above the age of 18 can apply for the grant. You must also be a person of sound mind, and you must not be bankrupt. And then, of course, you know, grants are not given to any person that is not, any person that is a company, except a public trustee. Are you together? Except a public trustee. So that is very important also as well for you to understand. So in terms of priority, of course, you know the rule of priority. What is the rule of priority? Any person that is listed under section 66, that is the spouse itself, the spouse herself or himself, the surviving children, a child or children. Apart from that, we have the public trustee. Also, we have the creditor. Those are the people that are entitled to make an application for grant. But guys, remember, you will need to understand the consequence of not, or the procedure where somebody has refused to take out a grant. When somebody refuses to take out a grant, what is the procedure? When somebody refuses to take out a grant, what is the procedure? That is citation. So citation, we'll talk about citation in a minute, but you need to understand what citation is and how citation works. Tunaelewana?
Yes.
All right. All right, so that is that. So I want us to go and talk about something in terms of the grant and what forms part of the grant. Of course, that is section 7. The details of the deceased person, the domicile, the list of beneficiaries, your relationship with the deceased person, the list of assets, and all that. That will form part of the the date of death. That will form part of the estate. Form part of the application for grant. So I'm hoping that you are moving together with me as we get deep into the discussion around the question to do with grants. Another thing that is also important about grants is the question to do with the sealing and resealing of grants. Now, for this specific provision, I want us to go and let me try if I can project my screen. Because one thing about grants that you need to understand, grants are very simple things. So what is it that must be on your radar at any time you discuss grant? Because there are very few things. The first one is the process of getting the grant, the types of grants, the limited grants. You need to understand that limited grants perspective. The next thing is the question of revocation and rectification of grants. How do you revoke a grant? Should there be a problem with the grant? How then do you revoke? A grant? How do you revoke a grant if there's a problem with the grant? Okay, how do you revoke a grant? That is very, very important. Revocation of of grants. So give me a second. All right. So revocation of grants. You must understand that as well. The next one is the question of sealing and resealing. Now, this is a topic that most people ignore. Most people ignore the question of sealing and resealing of grants. I don't know why people ignore this specific topic when it comes to grants, but you need to understand the concept of sealing and resealing of grants. We shall talk about sealing and resealing of grants again. Also, apart from sealing and resealing of grants, you also need to understand the question of contentious probate when it comes to grants. The first one is objections. The second one is citation. You must understand those two things, objections and citations. What is this thing about objections? What is this thing about citations? Okay, how do you cite somebody? Okay, you need to understand that as well. If there's a problem with the grant, how do you rectify the grant? How do you revoke the grant as well? Okay, you must understand that as well. And then you also need to understand the procedure, and this I'm saying very seriously, with a serious face, the procedure of administration of special estates. I'm not saying any of that can be said, neither am I saying no. But I'm just saying that if it is said and you don't read on it, there's an absolute surety that you will cry. Okay? So administration of estates which are special in nature. Okay? What is the first estate that is special in nature? The estate of an advocate. What is the procedure of administering an estate of an advocate who has died? If, for instance, I am an advocate, no, not me. I don't want to die. Let's use somebody. Person X is an advocate. Okay? Is having a law firm, practicing in whichever name and style, and this person has died. How do you administer the estate of a deceased person with an advocate? Okay? Those are some of the things you need to understand when it comes to grants. And then, of course, definitely, you know, the obvious ones like the duties and powers of the personal representatives. Now, if you read about the things I've just said right now, you will not be defeated to answer a question of whatever nature regarding grants. Are you together? So let's start at the very top. Let's start at the very, very top and talk about the question of sealing and resealing of grants. Now, for you to understand the question of sealing and resealing of grants, I'm trying to open up my screen so that we can I want to project my screen under section 72, but also you understand that there's an entire provision of sealing and resealing of grants. So what is it that you need to understand when it comes to sealing and resealing of grants? Section 77, sorry. Let's go down there. But the first thing you need to understand is the issue of domicile. Issue of domicile. Very important. What is domicile? Okay, guys, we are nearing the end of this discussion, so don't worry. Like I told you, probate is very simple. It has only a few things. The first thing is tested succession, which we have talked about. Okay, intestacy, we have talked about. Grants, we are finishing now. That is all you need to understand. That is all that you need to understand. If you understand that, you are good to go. You are good to go. Okay. All right, sawa. So let us talk about sealing and resealing of grants, and we start from the question of domicile. Now, if you take out a grant in a foreign country and you want to use that grant in Kenya to access the property in Kenya, you have to reseal that grant. Okay? You have to apply to the High Court and have that grant resealed. That is the sealing and resealing of grants. Sealing and resealing of grants under Section 77 of the law of succession act. So let me just put up my screen. The reason why I'm projecting this specific provision is because I know that most of you have not even read it. You know, some of you don't read these selling things. So I think my screen should be up. My screen should be up. All right, so my screen should be up there. So I want somebody to read for us section 77. And also as you read 77, I will inform you again, sorry, that we have an entire regulation on sealing and resealing of grants that also is important for you. So if you want to get more knowledge in terms of sealing and resealing of grants, so somebody read for us section 77. Kemoy.
All right, I will read. Sealing of Commonwealth and foreign grants. 77.1, where a court or other authority having jurisdiction in matters of probate or administration in any Commonwealth country or in any other foreign country designated by the Attorney General by notice in the Gazette has, either before or after the commencement of this Act, granted probate or letters of administration or an equivalent thereof in respect of the estate of the deceased person. Such grant may, on being produced to, and a copy thereof deposited with the High Court, be sealed with the seal of that court, and thereupon shall be of like force and effect, and have the same operation in Kenya, as if granted and confirmed by that court. 2. Before
Yes.
sealing a before
Yes,
sealing
two.
a before sealing a grant under subsection 1, the High Court A shall satisfy itself as to the payment of estate duty as provided by section 72. B may require such evidence, if any, as it thinks fit concerning the domicile of the deceased person. And C may, on the application of any creditor of the estate, require that the adequate security be given for the payment of debts due from the estate to the creditors residing in Kenya.
All right. So this is very important. This is very, very important. Okay. So the first thing is sealing and resealing of grants. And what are we saying? We're simply saying that if you have a grant that you want to execute in Kenya, and you've taken it out of Kenya, so in a Commonwealth country, then you have to apply to the High Court in the prescribed form and have that grant resealed. Okay, once it has been resealed, then it will have the same effect as if it was given in Kenya. Now, before the court can reseal a grant, before the court can seal a grant, the High Court must convince itself of the following issues. Number one, the payment of the estate duty. So you have to pay estate duty, and you have, okay, and you have, all right. So you have to pay the estate duty, and then the second one is that you must also provide evidence of domicile. Domicile is where you are ordinarily residing. So if you are a Kenyan and you ordinarily stay in Nairobi, then you are domiciled in Nairobi. If you are ordinarily staying in South Africa and working there, then of course you are domiciled. So where you domicile that has nothing to do with citizenship. So you are a citizen of Kenya, but you could be domiciled somewhere in Dubai, for instance. So there must be evidence of domicile. And then thirdly is if there's a question of if we have any creditors, okay, there must be security for payment of debts. Okay, so if there's any creditor that you have, okay, if there's any creditor that is that if the estate has a creditor, then the person that is applying for the resealing of the grant must put in security for the repayment of such debts. Okay, so that is the question of sealing and resealing of grants, what the court will consider when or before sealing and resealing a grant. So you need to understand the procedure of sealing that grant and what the court considers in sealing and resealing of that grant as well. So please go again to your subsidiary legislations, download the resealing rules and guidelines, and then you can find additional points there as well. So that is the question to do with sealing and resealing of grants. We're done with that. So while we're still on this document, I want us to move down because we've talked about making an application for grants, but there's no problem about that. We've talked about making an application for grant. Okay, we understand how to make an application for grant. We understand how to deal with grants once you given the grant, both the normal grants and the limited grants. Now, the question to do with confirmation of grants. Okay, I want us to get to confirmation of grants, and then we go to the question to do with rectification and revocation, because these are now what we call, these are the things we are calling now the contentious probate procedures. So confirmation of grant is very specific, that after the expiration of a period of 60 days or any such shorter period as the court may direct under subsection 3, from the date of any grant of representation, the holder of that grant shall apply to the court for confirmation of the grant in order to empower the distribution of any capital assets. So grant must always be confirmed. Okay. Now, if the court is satisfied that the grant was rightfully made to the applicant, the court may confirm the grant. Okay. Number 2, if the court is not satisfied, the court will decline the confirmation of the grant. And then, of course, the court can also order that that specific, part of the estate or the property that is held by the applicant be transferred to somebody else. So if the court doesn't trust that, they will administer the estate properly. Now, there's a question to do with the priority and the question of passing over that I need to explain under section 66 and confirmation of grants, and what is the relationship between those two things. 66 talks about the question to do with the priority of who can make an application for grants. Okay, 66 also give birth to what we are calling citation. 7.1 talks about confirmation, and 6.6 says the court may at any point skip the person in priority and make a grant to somebody else. Okay, it means you as the applicant, there are instances where the court will not confirm the grant in your name. Okay, if you are the deceased person's spouse, if there's evidence that since the deceased person died, you've been living off Quiver, whichever branch of Quiver you are managing on behalf of the management of Quiver, every morning at 4 a.m. or at 5, you're the one leaving. You come in early and you leave late. The court will not give you the grant, my friend. If there's evidence that you are not responsible as the guys, when you become a personal representative to the estate of the deceased person, you are being subjected to public scrutiny. So if the court gets wind of anything that is not proper, you will not get the grant. Are we together? So that is passing over. So that means that if we're supposed to give the spouse, we skip the spouse and give to somebody else. Also, in an instance where we have the deceased person, a spouse, and the children not being able to agree on the distribution of the estate, then the question is, who then do we give the grant? And that in that case, the court may give the grant to somebody who is third, and that person could be the public trustee. Now, because I've mentioned that, I've just remembered a point that is very, very important, which is the question of consent. What is consent? Somebody explain to me consent in application for grants. I think the Holy Spirit is just talking to me right now. If you guys were sick, I would treat you with the word of the Lord. Lakini sadaka mtoi, sadaka mnatuma kidogo man, hata ya kutoa hakuna. So hata maombi haizi fika mbali sana. But anyway, tell me, how do you deal with the question of consent when it comes to the application of grants in terms of consent? Somebody just unmute and tell me, consent, how do you address the question of consent? Nyamoko Omogeni, it is very important. Question of consent.
Are we talking of the consent of the other beneficiaries, the other people? Because at least a maximum of 4 people are supposed to apply.
When you say at least a maximum?
No, a maximum of 4 people are supposed to apply, but 1 person can apply. Now, you have to get consent from the other beneficiaries. you must have sat as a family and agreed that so and so should go and apply for those letters of administration.
Okay.
Am I right? I don't know.
Yes. Cherono. Consent. Fanny.
Just to add, they must be persons of 18 years and above who will give consent. So where we have minors, they don't have to give their consent.
How do they give consent? So this is the assignment, guys. This is the assignment. You know, the assignment is this. I'm just saying it because I think it's very important to mention that as an assignment. That talk to me about consent. Who is supposed to give consent? How do they give consent? And what is the consequence of they're not giving consent? That is the assignment. If you don't do that assignment, you will remember exactly what I'm saying right now in an exam tomorrow. Should that question come? So consent, who gives the consent, how they give consent, and the consequence of not getting that consent. Very, very important. All right, that is just by the way. Now let us go to something else. Let us go and talk about something a little bit different in terms of grants. That is the question. Oh, where's my screen? Let me bring my screen down, up again, so that I can explain. We can go through the question of rectification. Somebody read for us section 74 while you're there. Rectification. Tanya.
Well, I can read, but I have a question on consent. Can you hear me?
Sorry, I'm giving you a question on consent, and you're asking me a question on consent.
No, I just needed to ask, can we be told to draft a consent?
And I've told you, that is a wrong question to ask. When you're dealing with CLE, my friend, you don't ask what CLE can tell you to do. Okay? I've told you, CLE can even tell you to redraft the love letter that your great-grandfather used to conquer your great-grandmother. If at all he wrote a letter in 1881, CLE can tell you to go back and think about that letter and draft it. So what I'm saying is that anything can be drafted, including the things that have never happened in this world. So if you're asking whether CLE can do this, yes, absolutely. And you might get that question in an exam tomorrow, just the same way you're playing with it. You might get it and then you'll remember me very well for a very long time as you sit that exam. So please get the question on consent done. You might want to see the form. And the good thing with this thing is this, guys, everything that is in probate is all under the rules. So get the rules. If you are reading section 74 like this one, questions to do with alteration and rectification, then you go to section 74 and then you go to the rules and you're going to find the procedure in terms of what do you file, how does it look like, and all that and all that. Somebody read for me section 74 and then we can talk about the question of section 76. Quickly, guys, time is not on our side. I want you guys to go back and rest.
74. Errors may be rectified by court. Errors in names and descriptions, or in setting out the time and place of the deceased death, or the purpose in a limited grant, may be rectified by the court, and the grant of representation, whether before or after confirmation, may be altered and amended accordingly.
Thank you very much. So errors in names, a description, or setting out the time and place of deceased person's death, or the purpose in a limited grant may be rectified by the court, and the grant of representation, whether before or after confirmation, may be altered and amended accordingly. Okay, so that is the question of rectification. Now, I'm dealing with problems with the grant now. Problems with the grant. So let's go to revocation. Now, revocation is very important, guys, because we are saying at any point there's a problem with grant. you're allowed to apply for revocation of that grant. Revocation of grant is under section 76, and in this instance, we're simply saying that you, at any point, you realize there's a mistake with the grant, either a mistake on substance or content, you are allowed to make an application to court and ask the court, okay, ask the court to give an order revoking the grant. So read for us the revocation of grants. But if you are reading revocation of grants, you need to understand the grounds of revocation. That is the most important thing. Grounds of revocation. Why is that important? Because if an examiner is supposed to set a question on revocation of grants, they will be asking you, advise this person and the ground. So you need to tell them that based on this ground, specific ground, you can always apply for a revocation. Are we together? All right, sawa sawa. So somebody read.
A grant of representation, whether or not confirmed, may at any time be revoked or annulled if the court decides, either on application by any interested party or of its own motion. A, that the proceedings to obtain the grant were defective in substance, and B, that the grant was obtained fraudulently by the making of a false statement or by the concealment from the court of something material to the case. C, that the grant was obtained by means of an untrue allegation of a fact, essential in point of law, to justify the grant, notwithstanding that the allegation was made in ignorance or inadvertently. D, that the person to whom the grant was made has failed after due notice and without reasonable cause, either one, to apply for confirmation of the grant within 1 year from the date thereof, or such longer period as the court order or allow, or to proceed diligently with the administration of the estate, or 3, to produce to the court within the time prescribed any such inventory or account of administration as is required by the provisions of paragraphs E and G of section 83, or has produced any such inventory or account which is false in any material particular, or E, that the grant has become useless and inoperative through subsequent circumstances.
Thank you very much. So that is very clear, guys. That is very, very clear in as far as revocation of grant are concerned. Now, you might get a question on all the grounds or one of the grounds. You just need to understand which ground is this question making reference to. So what are we saying? We're saying, for instance, number 1, you'll be told that somebody has been left out of the will. Guys, remember, when you've been left out of the will, then there's a way to deal with that. 2 ways. The first thing is that if before the grant is confirmed, if it is before the grant is confirmed, then what do? You make an application for reasonable provisions. Okay? And in that instance, you are simply indicating that you have been left out of the will, and you are a dependent, and you should be given something, for instance. Are you together? That is exactly what I'm saying. But if the grant has already been confirmed, sorry, if the grant is already confirmed, you cannot use that ground of being left out. That is not a ground. Okay? The ground will then become, let's go back to 76. For instance, if you are left out intentionally, then you come and say that the grant was obtained fraudulently by making a false statement or concealment from the court, something material to the case. It means the person that made an application for grant did not include your name as a beneficiary. So because of that, it is a ground for revocation of the grant, because the grant was obtained fraudulently where your name was not included as a beneficiary. And in that instance, remember, the person that made an application for the grant, they are simply saying that I am the only beneficiary or we are the only beneficiaries. So that is fraudulent, and therefore it is a ground for revocation of the grant. Sorry. However, when it comes to point B, we are simply saying you've been left out, but not fraudulently. Okay? There was just an untrue allegation of fact. There's a difference between false and untrue. False is fraudulent when you know very well you're lying. That is very fraudulently false. Untrue simply means you are saying something that might be true or not. You're not, for instance, if you're saying, I don't have a sister. If you know very well you have a sister and you're saying, I don't have a sister, that is false. That is fraudulent. But if you're saying, I don't have a sister because you've never met any of your sisters, then that is untrue. So either of the two scenarios will fall under B or C. So look at the question. This person was left out fraudulently or just by a mean untrue allegation of fact. That will be a ground of revocation. Guys, are we getting along?
Yes, madam.
Yes, we are, madam.
All right. And then, of course, after that, we have the question of one person refusing to make an application for grant. So make an application for confirmation. If you don't make an application for confirmation of grant, the grant will be revoked. If you don't make an application for confirmation of a grant within 1 year, the grant will be revoked. You know that once you get the temporary grant, you have up to 1 year to apply for confirmation. So if you don't apply for confirmation, then the grant will be revoked. And remember that a grant can be revoked whether or not it has been confirmed. Are we together? So if it is confirmed, it can still be revoked. If it is not confirmed as well, it can still be revoked. Guys, are we together?
Yes, madam.
Yes, we are.
All right.
Yes, we are.
Now, that is the question of revocation of grant. So in terms of revocation, guys, you just need to advise on the procedure. What are they supposed to do? Make an application for revocation in the prescribed form on this ground. Okay, so if you are answering questions again, please, there are two things that are always in your control. Whenever you're doing exams, certain things are right on your, in your control. You can control them. Some things you can't control. For instance, you can't control content. Okay, you can't control content. Kama iko. Okay, but certain things you can control. Number one, you can control your handwriting. That is very possible. Just write well. Okay, write well. So in a question where there's a lot of stories to tell, like probate, you want to write very well. Don't write like somebody who has given up in life. Maybe you have, but you know, and don't write like a doctor. You are not a doctor. Give up. Okay, so please write well. Just have a nice pen, black and blue, and write well. Try to write well. That is the fastest way of getting marks. Are we together? So please take that also in consideration, because if you don't write well, it will be chaos. All right, so after that, guys, what I need to mention in this case, again, that is important, is another dispute when it comes to grants, which is the question of citation. Again, citation. The probate and administration rules talks about citation. Probate and administration rules talks about citation, that you need to understand at all times what citation is, So what is citation and when do we have citation? Okay. Now, why is this important? Why is it important? It is important because an examiner might be asking you that person XYZ has refused to take out a grant. How then do you deal with that scenario? How do you deal with the scenario of a person refusing to take out a grant? You cite them. So what is the procedure of citation? Somebody tell me. What is the procedure of citation? Huh? Gadoni, please.
Can you hear me?
Yes, I can.
Okay, so the procedure should be you make the application in the prescribed form, which then you shall serve upon the citee. After that, the citee should also enter appearance in the prescribed form as per your guidance. If no appearance is entered in 15 days, the citor may petition the court for grant.
You're very brief. You're very, very brief. Eve, add something, add some meat to that. Yes, you're right, but Eve, add something.
Okay, when the citor applies to the court, when the citor makes a petition to the court to make the grant to him or herself, the summons will be taken out.
Hey, what are you saying? Can you start from the beginning?
Okay, let me use the applicant. The applicant will say an affidavit asking the registry to issue the citation, and if there are enough grounds, the registrar will
Start from the beginning, please.
see. I've started from the beginning.
You think so?
Yes.
You will cry serious tears. Can you start that thing from the beginning in terms of citation?
The citor will make
Proceed.
The citor will make an application, and this application, if there are enough grounds, the registrar will send the citation. Then the citation itself
Application
is
for what? Application for what and how? Where? If? Ochieng. Give us something. Ochieng Abur. Ochieng is not there. Mwenga.
Okay, now a person, I just started the process again.
Yes, proceed from the process. What needs to happen?
A person who is not in priority will make an application to cite a person who is in priority but who has not applied for the grant. After making an application, the citor will have 15 days to make an appearance, and if the citor is willing to petition for grants, he or she will proceed and petition for the grants. But if the time limit has elapsed or expired and the citor has not applied for the grants, the citee will then go ahead and apply for the grants.
Okay. All right. Anyway, guys, so let's summarize the process of citation. Again, guys, citation happens in an instance where the person who is in priority is supposed to apply for the grant as they refuse to apply for the grant. And because they've refused to apply for the grant, then any person that is not and that is entitled to apply for the grant but does not apply for the grant will make an application for citation, will cite the applicant. Okay, will cite the applicant, and that is making an application for citation in the prescribed form. Okay, upon the receipt of that application, the registrar shall notify the citee, that is the person that has been cited, of the citation application, and ask them either to enter appearance, enter appearance within the prescribed 15 days, and indicate or intimate whether they will be making an application for the grant. Okay, if they indicate or if they renounce their right to apply for the grant, then of course the registrar shall notify the citor to put in their petition for the grant. Okay, if the citee does not renounce their right to apply for the grant, then they will be required to first show cause, the reasons why they haven't applied for the grant, and then subsequently they'll be required to put in the application for the grant or the respective grant that we have in that scenario. So this question can come in two ways. Number one, the examiner will be very direct with you. The examiner will say, please proceed and advise on the process of citation. That is very, very direct, more so where the examiner in this question is yourself. Okay, so if the person setting the exam is not you, then how again is the examiner going to be asking a question in this regard? You'll just be told that this person is supposed to apply for the grant. He hasn't applied for the grant. Now advise person XYZ on the consequence of not taking letters of administration. So when somebody fails to take out letters of administration, they can be cited. That is the process of citation. So you advise them on the process, or advise generally on the process of citation. So also you need to understand the question of citation. All right, so after that, guys, I think you need to understand again the personal representatives in terms of the administrators, in terms of the executors, their powers and their duties. I think that is something that we all know, the powers and duties of administrators. That is something that we all know very well. You know the powers and the duties of administrators. You know the power to collect, the power to sell, the power to pay, the power to account. Okay, still on the same thing, the duty to pay. Sorry, the duty to pay. What are we paying? Paying this the expenses of administration, paying the expenses, the burial expenses, paying the deceased person's debts. You know, so duty to pay is a wide duty, and then duty to account, duty to complete, duty to apply for confirmation. So there's so many duties and powers which are just intertwined within each other. And then of course offenses of personal representatives. Of course, number one will be including the question to do with administering an estate that is insolvent, administering an estate that is without squandering the estate, or failing to collect, failing to pay. Those are offenses. Anytime somebody doesn't do their duty, then that becomes an offense. All right, guys. Having said that, please remember, let's just do, I've remembered two things I've not mentioned. The first one is a question to do with the special accounts. I don't know whether somebody wants to explain to us how is the estate of an advocate administered? Somebody explain. Let me put my screen down. How do you administer the estate of an advocate, where the deceased person is an advocate and they're the law firm? How do you administer their estate? Somebody? Guys, are you here? Tanya?
Would I be right if a surviving partner is the one who...
No, you would not be right.
Okay.
Guys, how do you administer the estate of the deceased person? Kamiri John.
Yeah, I'm also trying like Tanya. I think what happens is that an advocate firm is guided by the Advocates Act, and now that there are clients' files that needs to be taken care of, there is the accountability of the whole estate. Upon the demise of an advocate, the Law Society of Kenya comes and appoints one who will now do the collection and the preservation of files, waiting for the direction of the court when it comes to the matter of now the confirmation of the grant. But I believe it is the LSK that appoints or confirms a partner to continue.
Okay. Thank you. That is a very good trial. Anyanzwa?
The annual application by advocates, they normally have a provision for whoever succeeds them in the event that the advocate dies. So either the person who has been nominated in that form will make an application for a limited grant for the specific purpose of winding up the particular law firm. It is administered separately from the estate of the advocate for other property. The law firm is settled separately, I believe.
So what is the procedure? Procedure is?
The advocate so appointed or the firm so appointed makes an application to the court.
Appointed by who?
Either the one who is nominated by the advocate in their form, or in the event that particular advocate is not present through the Law Society of Kenya, then the specific advocate makes an application to court for limited grant for specific purpose of dissolving the particular law firm.
All right. All right. So, guys, you need to understand the role of the Law Society of Kenya when it comes to administration of estates of advocates. And this is the reason, because this is a fact, because when you're dealing with an advocate, you have clients' accounts and clients' money that cannot be commingled with other money or other funds in that estate. And therefore, anytime an advocate dies, then if they have a farm, of course, the Law Society of Kenya, and of course, in this context, the president of the Law Society of Kenya will appoint an advocate who shall be the administrator of that specific estate. Okay. Now remember that the advocate in himself, of course, annually can always indicate who will be in charge of the administration of the estate should they die, administration of that farm should they die, or in case nobody is appointed or nominated, then the Law Society will nominate one person, an advocate of the High Court as well, to manage the administration of that estate. Now remember that courts have pronounced themselves on this question, and the courts have indicated that at any point you are dealing with an advocate's firm, then it is important to note that only an advocate can be appointed as an administrator, and then this advocate will be accountable to the spouse or the entitled administrators. So the entitled administrators are under Section 66, but in the context of an advocate having a law firm, then the person who is going to be the administrator is an advocate who is appointed by the Law Society of Kenya to proceed and manage that firm and dissolve the firm and pay out the clan's money and anything else that is due from that firm. And then, like I've said, the courts have added that this specific advocate is accountable to the entitled administrators under Section 66. So they'll have to account to the court and also account to the Law Society of Kenya, as well as account to the spouse of this advocate, should they have that. So that is what you need to understand. So should you be in a question where you need to advise somebody on appointment of advocates to manage the affairs of the estates of the deceased persons who are advocates, then of course you need to indicate that within the Law Society rules, any person, an advocate who has a farm dies, then the Law Society of Kenya or that advocate, of course, will nominate one person who will then be the administrator of that estate to administer the estate of the deceased person and their accounts, making sure that all the clans files and money are accounted for, and then filing a report with the court, the Law Society of Kenya, and the beneficiaries of that specific estate. Are you together? Now, a lay person cannot run a farm. A farm cannot be run or be dissolved by a lay person. Guys, are we together? So, in that context, I would expect you to proceed and also read cases. The Mbogo case. You remember the Mbogo case? Yes, read the cases on that aspect as well, so that you are on the same page as the law. All right. So, having said that, I want us to proceed and close down the class and call it a night. But before we do, let's just do a summary of everything that we have discussed ever since yesterday. That is the question to do with validity, tested succession, validity of wills. You must understand the question of validity of wills. There is no question about that. You need to understand the question to do with beneficiaries. That is the wife. That is the wife under section 3.5. Also the wife under cohabitation. And in terms of cohabitation, I've already indicated that you need to understand what are the factors that must be there for there to be cohabitation. Okay, what are the factors that must be there for there to be cohabitation? Because remember that cohabitation must be taken through the respective procedures that you need to go through. That is the question of cohabitation. That is the question of cohabitation. So that is as clear as that, as well as other provisions that I've already indicated, such as section 3, section 3.5. Now, apart from that, also we have gone and talked about the question to do with the rights of beneficiaries, including the rights of female children, including the rights of female children, where somebody is a deceased person, they've been survived by female children. What is the case of Rono versus Rono saying? What do you need to understand in as far as the rights are concerned? Okay. I've also talked about the question to do with in the context of polygamy, that is intestacy. Who are the beneficiaries? How is the estate supposed to be devolved? Who will become the administrators? Remember that in terms of administration, guys, I mentioned this some time back, that you can have a maximum of 4 administrators, and the list is provided for under section 60. Okay, a maximum of 4. So in this context, we have polygamy. If we have polygamy, then who can be the administrators in that estate? Of course, the surviving spouses, and in, of course, association with other beneficiaries, so long as there are a maximum of 4. Okay, so that is clear. That is clear in terms of your understanding. Also, we have gone and talked about the process of bequeathing, not really bequeathing, but the process of administering the estate of a deceased person to the beneficiaries as well. We have talked about that. Okay. Also, we have talked about reasonable provisions. Again, where somebody makes a will and bequeath their properties to their sons, their daughters, their sisters, their brothers, and then at some point some have been left out or one has been left out. What are the remedies within the law? So the remedies within the law I've said is under section 26, where you make an application, and then now that I'm remembering it, how do you make this application? How do you make an application for reasonable provisions? It is through summons, of course. Let all parties concerned convene before the judge in chambers. If it is the High Court, or convene before the magistrate in chambers for the hearing or for the determination of the following questions, or for the following issues will be determined before the court. So you give them the time and the date when they will be hearing that application. That is just the introductory part of the summons. The summons are all under the rules, but of course, you know the originating summons. These are just originating summons. And then you give us number 1, that the court do issue or do provide reasonable provision to the applicant or the applicants, okay, which application is further supported by the supporting affidavit of person XYZ and XYZ, or person XYZ, and then you proceed and give your supporting affidavit, which is form 16. So supporting affidavit is the same thing. Just have the caption. The caption is Republic of Kenya in the High Court, re-estate or the estate of person XYZ deceased, an application for reasonable provision. That is, proceed and give us the introductory paragraph. And then if it is affidavit, the same thing, affidavit in support of that. So guys, there's form 106 and then there's form 16. So look at form 106 and look at form 16 of the Law of Succession Act, that is in the rules. That is where the application for reasonable provision is form 106 and form 16. 106 is the application, that is the originating summon, and then form 16 is the form 16 is what we are calling the affidavit. So again, that is one thing that you might find in terms of drafting. Drafting a will, we have talked about drafting of a will. We've drafted a will in this class, so I will not mention much about that. That is also something that you need to also arm yourself with. Drafting a petition for grants, again, that is something we've done in this class. Again, you might also want to check that out, okay? Those are the only things that can be drafted in this exam. Drafting an application for injunction, should there be a question of intermeddling, then of course the normal notice of motion, supporting affidavit, asking for an order of injunction restraining person XYZ from doing XYZ. Essentially, I'm mentioning all the draftings that you can find in probate, either the petition, the application for reasonable provision, and of course the question to do with drafting of a will. So that one you already understand, and I don't want to talk much about that bit. Apart from that, we have talked about the question to do with intestacy, specifically the question to do with polygamy, the question to do with beneficiaries under intestacy, the instances and the rules of intestacy. We have also talked about the question of the schedule of distribution and how to distribute the estate of the deceased person when there is intestacy. Hiyo tumesha ongelea. And then the question to do with grants, we have gone through and talked about grants. In terms of grants, what have we said? Give me 1 second. So in terms of grants, again, know the various types of grants that we have. In terms of grants, you need to know the various types of grants that we have. Which types of grants do we have in probate? How do we address those grants? Grants of probate, grants of letters of administration intestate, you know. So all those types of grants, how do you address that as well? So that is something that I've also mentioned. We've gone through the process of getting the grant, the application process, all the way until the reporting stage. We have talked about the question of the limited grant ad colligenda bona, instances, ad litem instances, de boni, non-administrative instances. We have talked about pendentelite instances. So we've talked about that as well. And then the question of rectification of grants, again, you want to confirm again from the rules, how do you rectify the grant, and the question of revocation of grants. So in terms of revocation, I've said the grounds must always be under section 76. And this is an instance where if somebody's been left out, guys, there are two options. Somebody's left out, there are two options. The first option before the confirmation of grant is reasonable provisions. The second option is revocation. But if they've been left out, then the ground for being left out, the ground for revocation is not the fact that they are left out. Guys, you need to understand the dynamics around those two things. The first one, what am I saying? I'm saying that this person has been left out, okay? They've been left out of the will. That is fine. So at one point, they can go to court through reasonable provision, okay? And they're simply going to demonstrate that they are dependents. When you make an application under section 26, you are showing that you are a dependent of that estate, okay? That is when you make application under section 26. Okay. However, after the confirmation of grant, after grant has been issued, then you can't go under 26. The only available remedy is under section 76, revocation. However, under revocation, you cannot just go and tell the court that I want to revoke because I've been left out. No, that is not a ground for revocation. Now you have to interpret that ground to mean or to fall within the grounds that we have. For instance, if you've been left out, then your ground would be that the grant was obtained through a false allegation of fact. That would be the ground for you being left out. So I'm just giving dynamics an example so that you understand exactly what we are talking about. Okay. Guys, are we there?
Yes, we are. Yes, we are. Thank you.
All right, so that is something that we've talked about. The question of sealing of and resealing of grants, that is a very simple rule. We have gone through sealing and resealing of grants. And if you're going to make an application for resealing of the grant, how do you make that application? What are the grounds the court can consider before the court can reseal a grant that is issued from a foreign country, like the one we've seen under section 77? Okay. We have talked about the special properties that are exempted from wills, which we discussed also yesterday. That is the question of survivorship, joint ownership, and common ownership. So if it is joint ownership, what is supposed to happen with the property of a deceased person and where the property was jointly owned? And if it is ownership in common, what is supposed to happen? So again, you must also try to look at those various circumstances and comparisons between the different forms of ownership when it comes to properties in probate. So joint ownership, nomination, ownership in common. We have donatio, mortis causa. So those 4 issues, you need to have them at the fingertips. Number 1, survivorship. Okay, joint ownership. Number 2, donatio. Number 3, nomination. Number 4, ownership in common. So ownership in common is very important, as well as nomination, as well as survivorship, as well as donatio. You just need to understand what are the different, because there are principles, what are the different instances that those questions might or might come out, or how do we deal with properties in that respect? Okay, so that also you need to understand. Okay, again, in terms of the parties as well, we have talked about the question of the beneficiaries, cohabitees. What is cohabitation? What is the process in terms of cohabitation? What are the grounds that somebody needs to show? Okay, that they have an interest. For instance, if you are a cohabitee, that has a child, if you're the cohabitee and you have a child of the deceased person, and you're claiming presumption of marriage, what is the basis of that? So number 1, your child is a child under the law. That is section 3 defines a child to be the one born of the deceased person. 29 defines a child as a beneficiary. And then you go to the case of the mother. The mother is a cohabitee, and therefore for there to be presumption of marriage, there must be the rules in Otensaya Wanjiku versus public trustee, as well as Mary Nyambura case in the Supreme Court case. Guys, that is very clear in terms of the procedures, the contentious probate in terms of grants. We have talked about objections, citations, the question to do with protest, the question to do with revocation and rectification. Guys, all that combined, with whatever we discussed yesterday as well, should be able to deliver you to Canaan in as far as this unit is concerned. Okay, that being said and done, it is time for me to hang my boots. I will hang my boots for this series and say that it's been a good run for everybody. I appreciate everybody that has attended these classes, the series. It's been a long one, tiresome, exhausting, draining, and all manner of words you can say. But I want us to go and sit this exam and pass the papers. We shall meet in practice. We shall be there no matter what. If you meet me in practice, be kind to me tafadhali. Sinicharaze sana, mimi ni mwalimu. Okay? You need to have some shame when you deal with your teacher. But anyway, guys, I really wish you the very best of luck from the bottom of my heart. And for whatever reason, if we have crossed paths in not so pleasant of ways, don't take it to heart. You know, it's banter for purposes of having a class. There's nothing serious. Okay? But I want to apologize if there's anything, manner, or action that has crossed anybody in the wrong way. Notwithstanding, the most important thing is you guys go and pass. Once you pass, go home to your families, go practice, go be the best lawyer that you can, and go be good. So that is it for now. That is it for me. And I wish you the very best of luck. And of course, tomorrow we have LPM, that is the last class, LPM in the evening, so that we can usher out the 2024 November papers. At this juncture, I want to take questions as many as possible so that we can close the class. But I wish you guys the very best. For those who are leaving, I will share the recording in the group again so that you can revise and revise and revise. Please keep revising. Don't defer. Don't defer the exams right now, please. It's too late for you to defer. So just go sit the papers, both of them tomorrow, and then all shall be good. Olubi Dennis, talk to us.
This issue of those who've been left out of the will.